Welcome back to AM Live, and today we're discussing on the first day of hearing at the Supreme Court, and this is of the petition challenging the presidential election results that were announced on August 15th, and that being the declaration that William Samoei Ruto is a president-elect. That has been challenged, and the petition will be heard proper today, and for the next few days, up until Monday, when the judgment is expected, and the Supreme Court will be having the last word on who indeed is the fifth, on the 5th of September. So let's just remind everyone about the 9 main areas that will be focused on by the 7-judge bench. And that will be in the next 2 hours when the hearing begins. And I'll be talking to Duncan Khaemba, who will be at the Supreme Court live. And I have 2 guests in studio. We'll open the lines to you to ask the questions. I won't presume to, have the best questions leveled at some of our guests. We have 2 advocates. They have an understanding of the legal issues that have been raised, but it's not about prosecuting the merits or demerits of this case, but looking at the issues that have been raised and outlined for determination by the court during the pre-trial conference yesterday. And so we'll steer clear of merits and demerits, pros and cons of the various petitions that have been raised, and even affidavits and responses too. So let's just quickly look at the 9 areas and issues for determination. And the first one being, did technology deployed by IEBC meet standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results? And the second issue that will be a focus, was there interference with uploading and transmission of Forms 34A from the polling stations to the IEBC public portal? Let's go to the third issue that is going to be considered for determination. And was there a difference between Forms 34A uploaded on the IEBC public portal, forms received at the National Tallying Center, and forms issued to the agents at the polling stations? That's a question. To the fourth issue of determination, and did the postponement of elections in Kakamega and Mombasa counties, Kitui Rural, Kateliba, Rongai, and Pokot South constituencies, and Nyaki West and Kwajenga wards result in voter suppression to the detriment of Raila Odinga and Martha Karua? We've spoken about that a bit with Dr. Ojwang here, and that's one of the areas of determination. The fifth being, were there explainable discrepancies between the votes cast for presidential candidates and other elective positions? Perhaps here we will have the issue of some people probably decided to just vote for one person or one political position. To the sixth issue of determination, did IEBC carry out the verification, tallying, and declaration of results in accordance with Article 138(3)(c) and 138(10) of the Constitution? To the seventh and not least, did William Ruto attain 50% plus 1 vote of all the votes cast in accordance with Article 138(4) of the Constitution? And 8, were there irregularities and illegalities of such magnitude as to affect the final result of the presidential election? And 9, I see here a discrepancy in our issues raised. This is meant to read as 9. What reliefs and orders can the court grant or issue? So this is basically going to be the blueprint which they will be following. And even one of the issues in the orders that were given yesterday was on the polling stations. The results where the 15 polling stations, polling centers will be looked into, and not the entirety of it, just to see if it passes or fails the test of verifiability. So these are the issues we'll be canvassing and looking at with our 2 advocates in studio, and then jump to the Supreme Court with Duncan Khaemba, who will give us a contrast of the experience of covering this particular one and the previous presidential petitions, some issues arising in terms of differences, and even being the access to the service being granted to the petitioners. So, Dr. Ojwang, I'll involve you in one issue here as we move now to the particular areas of focus, and particularly this one being the concern that was raised by the Supreme Court. And I'm just taking from an article here from Capital by Jemima Mweni, just to give credit where it's due. And here, lawyers' parties warned against discussing merits of presidential petition outside the court. So, you know, from your legal background, what confines or what is a threshold of our discussion here, just to set the ground rules for us as we discuss it, because Justice Martha Koome warned lawyers in the presidential petition against discussing merits of the cases outside the Supreme Court. What about here, as we're talking on a case that is ongoing?
Right. Of course, you know, lawyers in the presidential petition most likely will avoid media at this point. The lawyers in the presidential petition at this point will obviously avoid media. And so I don't think it's a gag order beyond those lawyers on record in the Supreme Court. I think it is generally a good practice to give court time to determine issues, because, you know, media can sensationalize issue and can make a trial or hearing complicated, so that the focus of whatever happened to the courtroom is not interfered with from outside. Because if people are outside, and if there is much drama outside, and if there is much views outside, then it interferes with the fair rights and the fair hearing. But I think it's in the context of going foolhardy to talk to court and then again go out there and talk to the public. Some of it, you know, quickly spin to accusation on individual judges. What could be their possible reasoning? It prejudges. Some people could run, you know, the way maybe even newspaper have already summarized this as win versus losses. It already start making judges kind of get into the radar of the public and scrutiny before even their verdict. But I think overall that must be balanced by the right to information, the right to canvass, the right to open society that is in Article 6 of the Constitution, and 10, that we live in an open democratic society. And therefore, yes, if a lawyer is on record in court, then obviously it will not be fair for them to go there and then come to the media. But I think that media have the duty also to inform the public and to contextualize the issues. And so I don't take it so hard that it means people cannot discuss what is going on and even cite the law out of court. Because you know, it's an open court. And that open means that court must also allow itself to be scrutinized by the public. Of course, understanding that they are working in difficult situations, they have not given a verdict, but everybody is being watched, including the judges. And I think they need to know that our public are not spectators, that judges do not become the law, they interpret the law of the people, and so the law belongs to the people. And therefore it is, to that extent, a partnership in terms of I've not come to your desk, I've not told you rule this way, I'm not going to sensationalize, I'm not going to put you and straitjacket you, but I'm also not just a bird in the nest who is opening the mouth and the mother just vomits some food on it.
Yes.
I'm also a rational human being who can look and contextualize issues.
And this is, and you'll correct me if I'm wrong, the genesis of this discussion in terms of the threshold or our limits in discussing the Supreme Court petition as it goes on. And there was lawyer Omwanza Ombati who lodged a petition filed at the High Court challenging CJ's directions. This is in judgment petition number 242 of 2022, where it is read in part that a declaration be and is hereby issued that the Supreme Court presidential election petition amendment rules 2022 are unconstitutional for usurping the legislative power of Parliament, said Justice Tande. And I'm talking about that one just to refresh the memory of people, because there was some sort of relief after this High Court ruling because of the anticipation of the issues raised and where people want an interpretation or guidance as the case continues. So with this particular case that was brought forward by lawyer Omwanza Ombati, and there being questions about the new rules that had been presented to guide the presidential election petitions, this then allows us here this morning to have this discussion.
Yeah, of course, the judges are also human beings.
Yes.
They feel bad when they are overanalyzed. It was the era of a lot of tweets, some negative about the judges. And they don't have a fair opportunity to rebut and to answer. So they get disadvantaged. The court is labeled a certain way. The judges are profiled a certain way. And then it affects the administration of justice. Right. So that was the bigger picture and the bigger goal. But the other side was, nobody expects an advocate to be neutral. People expect a judge to be neutral. But an advocate is not neutral. And so what an advocate tells you, if they're representing somebody, cannot be taken as authority because they are representing a side of the case or a client. So the responsibility, it almost appeared that she was transferring the responsibility of the bench and the judge to advocates. Right. And the advocates advocate, and the judge sits in the middle and listen and give determination. And the irony was, we have seen judges go to radio. We have seen judges tweet. We have seen judges giving opinion even on the matter in the court. And the argument was, surely, in the balance of power, can you say that an advocate's comment can make justice, can affect justice, or can affect the bench? Maybe it is more of maybe a colleague or a judge or what other courts say, but not an advocate who is simply under the court in the balance of power. You don't see how their comment can put court in an uncomfortable situation. But even beyond that, the whole idea that you go to court, you don't get orders, and then you go blog about judges. And that has been common, and it's not a fair practice because there is appeal mechanism. Yes. There is a way you can ask a judge to review. But when you now go into social media, which, by the way, for bad manners, even sometimes lawyers, when they find the judge might not rule for them, they come with flimsy accusation of saying, I think you should recuse yourself because you are related to this litigant. Right. And so some judges just give up and say, fine. Or some judges stay put and say, I'm not going to be intimidated. But overall, yes, those rules appeared to roll back the time we are in Kenya. But where we are seeing Chief Justice coming from Tanzania, where we are seeing that everybody is admiring the amount of our accountability and amount of our openness and democratic space that Kenya have done. It cannot be democratic everywhere except in the court.
But there's something that was clarified even after this particular judgment. Despite the High Court judgment, not ruling, I said earlier, despite the High Court judgment declaring the new Supreme Court presidential election petition rule on the sub judice rule unconstitutional on procedural ground, failure by the Supreme Court to conduct public participation before making the rule, litigants and advocates should be on notice that they are still bound by the sub judice rule. So does this just apply to those who are in the petition, or even an advocate like you who would be discussing this issue on a forum like this?
Myself, I don't have an active license.
Yes.
But I think that there is role of advocate to support justice and to be an officer of the court. An advocate is an officer of the court. And that is why they have a duty to the court.
Yes.
Including not lying to the court, or including not duping or misleading the court. So that duty overall that every advocate have, because an advocate is an office of the court. That's why if they go to jail or prison to see somebody, they will enter places that ordinary people will not enter, because they are part of the judicial system or justice system, not judicial, but justice system.
Yes.
So they have the overall duty. But that there's a difference between a judge who is on record and lawyer who is on record and one who is not on record, and what should be said. But out of deference, out of respect for whatever is happening in the temple of justice, there is an element of not getting into the merit, but yes, of course, highlighting issues, highlighting judgments within the hearing, and putting things in context is also a duty of every advocate, including to inform the client. Remember, the order by the Chief Justice was so broad that you should not speak out of court. How do you even brief your client? Because that is out of court.
Exactly. And the reason I have gone to this discussion in terms of laying the ground rules for us discussing the petition, the presidential election petition, is because there are rules to this, and we wouldn't want to be out of order. But there's something else that is at play, Dr. Juang, and as we wait on Norman Magai to start the conversation proper on the 9 issues that have been outlined for determination by the 7-judge bench, and that is, you've mentioned social media and some purported audio clips being thrown there and shared widely. In terms of, even if it is substantial evidence to whatever case or going to favor anyone, is it in any way going to influence the ongoing case at the Supreme Court? I'm sure you've heard some of the audio clips that have been shared. Dr.
Yeah, you know, judge is trained to cut the noise out, block the noise, block undue influence, even from their own relatives, maybe even spouse, even from TV, and go base their decision on record. Right. Because, you know, media are supposed to be neutral, but they don't have a higher burden, and sometimes they fail at crucial juncture to be.
Yes.
And every other institution, more so now social media. There's a lot of spinning and a lot of single narratives. So I don't think we should be so much worried about that, because a judge is trained and meant to stay on the issues. Ideally, not just a judge, but even a lawyer. And that is the ability of lawyers, that the ability to spot issues and know non-issues. Know that those might be important, but they are not related. Yes. Remember, throughout our education system, we do those paragraphs, and in those paragraphs, we are told what is the issue of this paragraph. What do you think paragraph 4 is talking about? Yeah. And it is training us to have ability to spot issue and to know non-issues. And that is the ability that I think more than any other ability is very important for a lawyer. That a lawyer should have ability for issue spotting and know an issue. So a client do not come to you and say, I think I have a case of self-defense. They just give you a story with what is irrelevant, what is emotional, what is sensational, and then it is up to you to say, I think this and this are the issue. There might be a little bit of this, but that is too remote. Right. And that is why lawyers are not the same. Others are successful, others are weak lawyers because of the ability to spot issue. So the judges have that ability, which is the ability they have now been able to summarize the issues very well out of all those issues floating. And that finally is also the ability to say that much of the drama we are seeing are actually not going to play in the courtroom. If you saw from the first day, they have really lowered the drama. And I think we live in the world where we have seen a lot of trial movies and series, but this is not going to be as dramatized.
Right.
Of course, once in a while, you'll find a lawyer who might pull drama. It is usually not for the court. It is usually not for other lawyers because they know what are the main issue. It is for the public. Right. And it is to catch an eye of a potential client.
So basically, whatever is produced, and as we make room now for Advocate Norman Magaya to join us in studio, he's just walked in. Asante for coming. Just to set the record straight, whatever the layman, Mwananchi, the person watching, and we'll open the lines to you to throw your questions to the legal minds here in studio. My director will just be giving the numbers there, the bottom of your screen, to call in at some point. That Dr. Ojwang, basically, even if you see CCTV footage purporting to be of such and such individual meeting, maybe the commissioner at such a point, and audio clips being shared, and indeed, it is audio clips of some crucial players in the election period. None of that is admissible in court unless it was in the affidavit. That's what you're saying.
Parties are restricted to their pleading. You cannot expand your case in the middle, which is why they came out and clearly said this is the amount of scrutiny. We are not going to have a fishing expedition. And finally, the idea that, you know, this rule of evidence, and, you know, I saw it in the newspaper, usually does not count in most cases, that within those rule of evidence, there is a lot of things that sometimes could be locked out, could be just hearsay. Sometimes they are meant to achieve certain end, because this case, I think, to some extent, is tried in two fronts, unfortunately, in the court and in the public opinion. Justice must be seen to be done and felt to be done.
Right.
But yes, in the court, even from the directions yesterday, there is already a very low amount of what will come in terms of drama.
Okay, so that is clear to the Mwananchi, the layman, me being one of them, that whatever you hear, whatever you see, whether it's on social media, if it's not, you know, in one of the affidavits or in the petition, it is not admissible and it won't influence the decision on the 9 issues. Good morning, Bwana Norman Magaya. It has been long hours for you. I'm sure you were serving the nation elsewhere on another station late last night, and I have disrupted your morning, but thank you for allowing me to do so. But I'm sure the issues are fresh in your mind in terms of what came up from the pre-trial conference yesterday. And the rules have been laid, and now the hearing begins in about an hour and a half, 9 a.m. If they do keep or stick to the time that they announced yesterday. I'm sure it's been long hours for the judges as well. But yes, Karibu, for you, there were the 9 issues and there were some orders. First of all, let's actually start with the orders, some of the orders that were given in terms of we will consider this, we will consider that, or we will not consider this and that. What stood out for you?
I think if you follow the proceedings of the Supreme Court, this is the 4th presidential election petition since the promulgation of the new constitution. Coming from 2013, the process has evolved. I think more experience has come on board. And over time, we now have more seasoned practitioners sitting on the bench at the Supreme Court. And that gives a level of composure that we're seeing now. But above all, I think what the court has managed to do, unlike in previous situations, is to create an environment, especially drawing from the 2013 experience, that where pleadings and evidence has been filed on time, it is the duty of court to put most of this evidentiary material to test by allowing them to be canvassed before the court. And that's why most of the rulings yesterday, especially from interlocutor applications that were seeking to expunge material or to seek prohibition of participation of some parties, court was able to lock it out and dismiss such applications. The second thing is that unlike 2017, when we had interlocutor applications being canvassed viva voce before court, this time around the court dispensed with most of the applications ex parte and handed around rulings. And I think that has an effect in the manner in which the court is managing the case, because yesterday will have been spent on most of these applications, but now a lot of time was spent on setting the stage for today. What needed to be settled is settled. The parties know exactly what to anticipate. The 9 issues, I think, present a fair chance of the issues before court, everything emerging from the election being canvassed and distilled before court. And I think we should be able, there is enough material on court record for court to be able to make its decision as to whether there was an election that met the standards required by the Constitution and our election laws on the 9th of August.
Right. Yes. And you mentioned how the environment is different in contrast to the other 3 under the other 3 petitions under the new constitution, the 2010 constitution. And one of the main issues, I don't know if it stands out for you as one of the developments that will be a determinant factor, and that is access to the server being granted.
I think one of the things that is now part and parcel of our electoral process is election technology. And it has a historical perspective in the management of our elections. This was part of the recommendations from the Krieg report after the 2007 elections were bungled. And over time, then questions have evolved as to how this technology is deployed, its integrity, whether it meets the standards set out in the law. And I think it was on test in 2017, and it's on a test now, whether the Electoral Commission has been able to deploy technology to ensure that as much as possible, it enhances and gives a fair chance for the will of Kenyans to be expressed as accurately as possible, as expressed at the polling station. And I think granting the orders for scrutiny, access to servers and all that is part of the developing jurisprudence at the Supreme Court. It was granted in 2017. They have also granted it now. And I think it provides a fair chance to parties. It gives the courts, although given the limited time, what normally happens with this scrutiny is that court simply wants to develop a pattern from the limited access granted, from the limited scrutiny granted. Does it present a picture, a fair picture of what is captured in the pleadings? And this is what happened in 2017. Remember that largely the 2017 election was annulled on account of process. That IBC was not able to convince court that the result transmission had been conducted in a manner that was consistent with the law. And that question still is on trial again before the Supreme Court. And I think the scrutiny will be able to reveal whether indeed what was announced at the polling station is exactly what happened at the National Tally Center, and is exactly what Chebukati announced. That will be able to be handled. And from where I see it, from what I've seen on what is on the court record, I think we will have a fair chance of knowing whether the results that are announced by Chebukati are verifiable, they are accountable, and they can be ascertained right from the materials he has provided, as well as whether this result indeed is what happened at the
right.
polling station. Because 2017, we had the position that what was being announced at the National Tele Center was materially different from what had happened at the polling station. And remember that 2013, the gap between Uhuru and Raila was almost 1 million votes. Right now, we're dealing with a very narrow path. And even 2017, despite the wide gap, the Supreme Court was moved that even though the result was, the margin in difference between the two candidates was substantial, that the process was not convincing. It did not meet the criteria required by the law.
So process, again, might be the underlining issue
yes,
that will be determining this particular case. And I'm engaging you a bit more because earlier with Dr. Juang, we did speak about some of the, what you'd call consequential determinations from the pre-trial conference, among them the access to the server. But now, Dr. feel free to interject as we continue with the conversation because we'll be going issue by issue. And you've mentioned the first one there on the technology and verifiability, security aspects, the integrity of it and whether it was transparent. But there was also something else that's being interpreted. And I don't know, we've discussed it with Dr. Juang. I don't know if from your perspective or your standpoint, it is accurate that there are some wins and losses for the main participants in this issue, and it has been interpreted as a win for Chebukati and as the Supreme Court dismissed responses filed on behalf of the electoral agency by 4 commissioners led by Vice Chair Juliana Cherera. And this, as has been framed by The Nation, the Daily Nation, is a win for Chair Wafula Chebukati on day one. Is that how you see it? Especially as the Supreme Court says we're not getting involved in the divisions within IEBC.
It's actually not a win for Chebukati, it's a loss. And I think Nation got it absolutely wrong. I pointed it out yesterday that you misapprehended the ruling. The Supreme Court was very emphatic that it will not delve into the internal issues of IEBC and seek to determine who will represent IEBC. Yeah. What it did was to strike out a notice of appointment of advocates by Issa Mansour, allowing Muita and Issa to come on record for IEBC. But it did not oust their participation in the process. Remember that the court said both functions of IEBC will be able to be represented. And even after striking out the notice of appointment, it went still and added a rider that those 4 commissioners were at liberty to retain the services of Senior Counsel Paul Muita and Issa Mansour. So if you look at it in substance, the material question that was struck out was only a notice of appointment. The pleadings, the affidavits, the evidence put on the record by the 4 commissioners remain. Right. So it's not correct to say that it's a victory for Chebukati. And I think that what is happening, it's actually a good thing. Finally, let Kenya face its demons and have them resolved in this election. We have suffered for so long with the conspiracy of silence. I think it's a good time that we are lifting this corporate veil. Right. Let the 2 functions of IEBC play out at the Supreme Court. Kenyans will understand what happens in these state agencies. And it's not the first time that we are having divisions at IEBC. 2007, remember after Kivuitu had made his pronouncement, you had commissioners who came to the media and said they were not convinced that that election was conducted in a manner contemplated in law. Yes. 2013, we had the same thing. Divisions in the commission, and you saw what followed in the aftermath of the annulment of the election by the Supreme Court. And it raises questions on the competence, credibility, and ability of Wafula Chebukati as a chairman. You cannot be a chairman who has presided over 2 regimes at IEBC, 4 commissioners walking off at every single time. It can't be the problem with the commissioners. I think for the first time, the competence and the credibility and ability of Wafula Chebukati as a chairman of an electoral body is actually an issue that should concern Kenyans.
Dr. Juang, jump in here because it was brought up in, we spoke about it in terms of wins and losses for Chebukati, for Ruto, for Raila, the petitioners, the respondents. And in this case, on the issue of Chebukati, it was seen or is being interpreted as an advantage for Chebukati in maintaining his line of evidence. Would you agree before we take a call?
You know, to some extent, as Dr. Magaya is saying, none of what the 4 commissioners had put on record was expunged. Their affidavit and their pleading, of course, court noted that they didn't want interested parties, and they noted that generally it appears that their story supports or is against what naturally you'll think commissioners will be protecting the commission. But court, yes, were clear that we don't want to get into the drama of what happens in the commission. and that part, I think, have lowered the dramatical effect that the split was to play, because they are not so much interested in who is not getting along with who. But then they went further to say that you know, the power to procure, they didn't use those terms, but who get to speak for IBC in terms of its lawyers on record. It is Githu Muigai. It is the team representing the commission. So then the authority, and I think the weight of who speak for the commission, you know, they were not coming initially to speak as individuals. They're also coming as a commission. That's why they had procured the services, which was strike out, because they were saying, no, where is the commission? The commission is this side. They were told, no, those are not commission lawyers. Now you can bring them on board as your lawyers. You have a right to come as an individual, of course, an individual commissioner, and tell us your mind. And so that is where I think it kind of gave a clarity a little bit.
But not necessarily advantage to Chebukati in his line of evidence.
In terms of who speak for the commission, who is the commission lawyers on record, is Githu Muigai is not the one hired by the 4 commissioners. They are there on their individual capacity as commissioners, but not the commission.
Got you on that. Let's take some calls. Let's take some calls before they...
That is not
I'll give you an opportunity to clarify.
I don't want that to go away.
Norman Magaya. You'll have your rebuttal. It's just because there's viewers who have been following and they're putting questions across to you. So let's just note them before the calls drop, and I'll give you an opportunity to respond. Ezekiel from Eldoret, he's watching from there. Good morning, Ezekiel. What's your question to our guest? Carry on, and just if you can, please raise your voice, and if you have your television set on, please switch it off. It will disrupt the clear communication.
I want to hear in Swahili.
Say again?
Yeah?
Yes. Unaweza zungumza kwa Kiswahili? Ni sawa?
Yes. Kiswahili ni sawa.
Yes.
Yeah, kwa maana mambo mengi nilikuwa nikifuatilia sana, lakini kuna mambo mengine Kiingereza sana inanifika chenga.
Haina noma. Endelea na Kiswahili.
Yes. Nilikuwa nasema vile maandalizi ya Cuba vile wamefanya maandalizi.
Yes.
Maandalizi yaliyo bora zaidi.
Yes.
Na imekuwa tofauti sana na maandalizi mengine hapa awali. Kwa hivyo sasa vile tunapofuatilia tunaona vile kote inaendelea. Tunaridhika penye tuko. Tunaona inaendelea vyema zaidi.
Asante. Hayo ndo maoni yako. Asante Ezekiel from Eldoret. And let's take Catherine, who's watching and calling in from Ngong. Good morning, Catherine. What's your question, observation, as we continue with the conversation?
Good morning to you, Mark. How are you?
Salama.
I've been following this,
Yes.
And I think the 2 elephants in the house, or in the court,
yes,
is the Venezuelan,
yes,
and the 4 commissioners, the Cherewa commissioners.
Yes.
Those are the 2 elephants in the court, the Supreme Court.
Okay.
That's where the evidence lies.
Uh-huh.
And that's why even I saw yesterday the Professor J.P. Muigai
Yes.
getting very irrational once this wasn't stopped, the evidence for the 4 commissioners.
Okay.
They have been following this.
All right.
And I also feel that even the Supreme Judge Court judges
Yes.
have been following as well.
Right.
Yeah.
Okay, thank you for that observation. And now, Norman Magai, as you follow, Ezekiel from Eldoret says something that you mentioned in your opening remarks, that maandalizi ni bora zaidi in comparison to the other petitions, so he's just making an observation on the same. But Catherine brings up an issue that she sees as the 2 elephants in the room and in the court, the Venezuelans, the issue of the Venezuelans, and the 4 commissioners and the division that has been between the IEBC. And there's a point that Dr. brought up. First of all, I don't know if you have a direct response to either one of the callers.
One, I think it's good to have a clarification.
Yes, sir.
That court did not delve into the question of who has the right to procure. Okay? Representation.
This is in response to Dr.
Yes, representation on behalf of IEBC. Court avoided that question for obvious reasons. That eventually, when determining this petition, the question of the ability to make the decision to tally, verify, and declare is a material question before court. And I think court was tactical in avoiding this question at the preliminary stage, because it will have given away its thinking in how it will dispose of that issue.
Preemptive in a way.
Yes, at the end. Because the manner in which it disposes of that question could have a significant bearing in the way in which the petition goes. So they were very tactical.
Yes, there was a point where the deputy did say, ignore what I have just said.
Yes, they were very tactical.
Do you believe it's the same?
Yes, but the most important thing is that one of the things why the notice of appointment by Isa Manzuru was struck out was it was filed out of time. Okay. Yeah, it was dealing with clear timelines in the manner in which pleadings are supposed to be filed before the Supreme Court in an election petition. And so you are not having a settled question of who indeed will then be able to procure services on behalf of IEBC. And actually, the media continuously, you have also framed this question wrong. The majority cannot be dissenting. By jurisprudence, it is the minority that dissent. So 4 commissioners constituting the majority in a commission cannot dissent. Yeah, and that's the question that court avoided answering.
The framing there dissenting in terms of them not being in agreement with the chair.
And found a way to say, I mean, we're not dealing with the question of representation. We are not stopping participation of Senior Counsel Muita and Isa Mansour. You guys can use it. And then you go back to the manner in which court had framed how parties will present their cases before court and said, largely the 4 commissioners, their line of argument is in support of the petitions. And so their time allocation was put on the side of the petitioners. And the part of IBC that is opposite to the petition was distilled and put on the other side and allocated more time, okay? Because then they stand on their own to defend against the 8 election petitions. So that is also discernible. Thirdly, remember that Ruto had filed an application opposing the participation of the commissioners before the Supreme Court, and this application was one of the applications that were dismissed by the rulings handed down yesterday morning. So I think the thinking of the court is that they want to hear from both sides of IEBC. They will make their decisions at the end. But it will have given away, as I've said, their line of thinking if they had resolved this question at the stage they were asked to. And I think a trap was being set for them, which they cleverly avoided. Remember that we've had a situation in 2013. The presidential election petition was largely dead and done. Immediately, the affidavits were expunged from the record. If court had made the decision substantially and resolved that question of representation on the part of IEBC yesterday, by now we will be knowing to a large extent the thinking of the court in approaching the petition, which is what they avoided.
Right.
Yeah, no, I think Magaya is executing the Azimio theory of the case. And to that extent, that is the theory. That is the effect that it is meant to bear on this trial. And that is their theory of the case.
Okay.
But when you look at the oral submission of Senior Counsel Githu Muigai on this issue, and then which was an oral application, and you find the answer that was given, that the issue of which pleadings belong to the commission is settled. Who is the commission lawyer is settled. And yes, it is true that the other commissioners were not struck out, and the application to strike them out was rejected.
Yeah.
And so they remained there, but not as the commission, but commissioners.
So what's the import of this is ideally, and for the layman, the question, is it that they have determined that in terms of, for this particular petition, the representation for IEBC, they recognize one side and not the other? That is Githu Muigai and not Paul Mwite. Is that the import of this? Or is it just that they said they have the right to have all their representation as they would like?
I think, Mark, it's fair to say that Dr. Yuang is also simply executing a Kenya Kwanza theory, okay? Of who procures on behalf of IEBC and who speaks on behalf of IEBC.
Yes.
And he's simply splitting hairs. None of evidentiary material has been expunged. It's only a notice of appointment of advocate. It doesn't settle the question in the manner he's trying to expand it. Yeah, it doesn't matter how you torture the ruling by the Supreme Court.
For the layman,
it doesn't give you the kind
for
of
the layman, explain this though. Will then the seven-judge bench
to the layman
recognize the IEBC representation as Paul Mwite or Githu Muigai?
Yes, to the layman is that the Supreme Court is going to hear the two functions of IEBC. It is then up to the Supreme Court to decide who
but he did say it won't get involved in the internal divisions.
It didn't resolve that question at that point. But I can assure you that in the totality of it, in the final judgment, the Supreme Court will deal with that.
It will.
It will.
Because it's a
no doubt.
issue.
It's a substantive issue.
Remember,
and not even for now, even for the future. Yes.
But before that direction, there were two commission lawyers.
Yes.
But after that direction, there is now clarity on who are the commission lawyers. And that is what I'm saying. That before, this other side were not coming as Cherara and the other commissioners' lawyers. They were coming as IBC lawyers, which now there is only one commission lawyers, and that is the Githu team. And that's the meaning that now IBC is represented and the commissioners are represented, the four commissioners. And of course, as Magai is saying, their affidavit and their story will be heard in court as commissioners, but not as the commission.
Okay. Let's now get to the 9 issues, gentlemen. And first of all, any response to what the two callers brought up? Of course, Ezekiel from Eldoret, it was more of an observation that it seems that this time the petition, things have advanced. You brought this up, so I believe you agree with that. But I just want to give an opportunity to respond to what was raised by Catherine, her seeing that the main issues here, the two elephants in the room, as she says, is the issue of the Venezuelans and the 4 commissioners. That's where the evidence lies. But you both said that it will have to pronounce itself on this in terms of the factions and the divisions. Any response directly as you were listening?
She wasn't very clear. I didn't hear much.
Okay.
But remember, so the court have do not want much of the drama.
Yes.
In what is happening in the commission. And I think they said, you have your mechanism of resolving your issues. So don't bring it to the floor here or to the court. But overall, we will hear you. Yes, we will hear you. And we will also hear the commission. Now, and you are coming as a commissioner who has a different opinion, and you'll be heard because you have submitted and you are named. Remember, the clever thing that the petition did is to name these commissioners one by one. And the application from Ruto's side was, no, they are part of the commission. There is only one story. But the court said, no, we must hear them.
Okay. Any response to what you heard from the viewers?
So the Venezuelan, I think that might come in the issue of the integrity of the digital. Because remember, it's by law, and it is required that there is the manual aspect and there's the digital aspect.
Okay.
And of course, the story of what happened and what is the bearing of the Venezuelan to the digital is probably an issue, yes.
To technology. Magaya?
I think if you look at the way the issues have been framed, as I said, you have 8 petitions. And I think court did a decent job in distilling. Those issues present a fair chance of having each party canvass its case on the basis of the evidence that is on the court record and be able to dispense with the issues before court. And as I said, as I had mentioned earlier, that what's happening in court now is largely not a bad issue. Remember that a general election that is presented to Kenyans at the end of every 5 years, we're not just choosing a president, we are choosing the commander-in-chief of this country. And the manner in which that process is undertaken, I think, is a matter that has evolved in our elections over time. But continuously, the country is led down in the manner in which these elections are managed, the manner in which people vote. The voting is largely exemplary. Everything happens well. But from what has happened in 2017 and right now, I think we're starting to see a pattern emerging. Okay. That election manipulation, electoral fraud is actually a project that is conceived early enough. It is appearing from 2022 that actually somebody sets up an election manipulation project team that undertakes this process for a long time, because the precision, the manner in which it was executed this time round is not an exercise that was done on just the polling day. It is something that was planned over time to be able to execute it in the manner in which it has been done. The lucky thing is that we did have a situation where this will be able to be swept under the table, and we have these issues coming before court. It's not about who wins and who loses in this petition largely, but it helps us fix some of these loopholes as we approach future elections.
Okay. Yeah. All right. Let's take a break at this point and then get to the 9 issues now. Now that we are both here, and we will also be joined from the Supreme Court by Duncan Haemba, who is there right now and in anticipation of the hearing starting in about an hour's time. He will be giving us a report there on what is happening at the Supreme Court. He'll be joining us live. The lines will still be open for you to call in and give your questions and seek clarification on the issues that have been raised. And 9 issues or areas of consideration for the determination that we are looking forward to on Monday, the 5th of September. Stay with AM Live.
Your generosity imesaidia kuignite a love for reading in our children. Nunua any Cadbury Story Edition packs, scan QR code, na generously share your homegrown story. Cadbury, there's a glass and a half in everyone.
Unapohisi maumivu, unahitaji kitulizo kinachotegemeka. Jaribu Panadol Advance. Ikitumia teknolojia Panadol Optizorb, tembe hiyo hufyonzwa haraka na kuandaa kitulizo cha haraka dhidi ya maumivu. Jaribu Panadol Advance.
Kwa nini kunichenga chenga chenga
Miaka
chenga?
mitatu kule Japan,
Kidogo tu.
usomea kudunga watu
Utamu tu.
sindano.
Jamani, tunachenga mpira ndani ya gumzo la Sato.
Sitaki mzee aliezeka, nataka kijana. Sasa ni
Kadro wewe una vita na sisi nikueleze.
Bila utakuota kidogo.
Ngoja. Hata mimi.
Tukijadili masuala yanayokuathiri wewe katika jamii.
Hii ni sura yangu na hii sura imeolewa.
Kuna mambo mingi kwa ndoa ambayo hayahusiani na mapenzi peke yake.
Penda kweli, lakini pia tumia bongo.
Naloogopwa kusema na wengine Frida twaliweka wazi.
Huyo mwanamume wa kizungu akaja na pupa, mwisho akabakishwa na kachumbari na maavocado.
I'm not a burden to her. Like she'll be feeding me like this.
Huyo babu mimi namuelewa. Anajua anakoenda. Shiro, hata afadhali ungeniuliza ningepa leo ndugu yangu mdogo. Ombea.
Kama mbunge wako umefanya vizuri sana kunipigia simu. Nikishika simu yako hivi, kitu ya kwanza, okoa jahazi yako, nalipa. Fuliza, nalipa. Hautawahi fanya please call me tena. Those are things of the past. Airtime yenye nitakununulia ni for life. Wewe na familia yako, nikupatie bundles. Utakuwa kwa internet 24/7. Hata ukikufa mahali utaenda bado utakuwa unasafia huko. Mimi nakwambia, kama mbunge wako hautawahi teseka tena, hautawahi reverse call mtu tena kwa sababu umenipigia simu.
To get political promises, dial *812*799#.
Skiza, non-nation. The Nairobi Hospital Accident and Emergency Center is manned by well-trained doctors and emergency nurses who are focused at saving lives. With a network of labs, you're guaranteed of accurate medical test results. The Nairobi Hospital is a center of renal excellence, providing cutting-edge technology with over 10 dialysis machines.
Welcome back to AM Live. Duncan Hyamba, report on the ground at the Supreme Court. We'll be following the hearing when it starts in about an hour's time. Will be joining us with a look at the activity and what is building up to that. And the focus will be there for the next several hours and days. And in fact, gentlemen, we were talking about this during the break, how it will play out. Norman Magaya, just for the layman, everyone is talking about Monday, the 5th. They will know the 5th, at least from the judgment. But from today, how will it play out?
Today, I think, is the petitioners' day in court for them to prosecute their case. And if you look at the allocation of time, they are likely to take the entire day. And then we have Thursday as the respondents' day in court. Remember that court decided that the parties participating as Amish will only put in written submissions.
Yes.
And then we have a day for rejoinders on Friday. And I think normally court allocates 15-30 minutes for parties to comment on the scrutiny report, make any presentations and submissions, if any. And then the judges will then retire to consider and issue their ruling.
That's Saturday, Sunday.
The law gives them up to Monday, 5th September, but they are at liberty to deliver their ruling any day between that Friday evening and Monday evening. Yeah, so they could surprise the country with a ruling on Sunday.
All right, we'll see about that. Everyone is waiting on that. And now to the 9 issues. And I'll ask you first, Daktari, will the 9 issues that have been outlined for determination determine the verdict or lead to the verdict? In that, a majority of the 7-judge bench, for instance, agreeing on a majority of the issues therein, or can one issue, say number 8, unanimously agreed on by be the deciding factor? Essentially, what I'm asking is, what will the threshold be, or what can we anticipate?
The threshold is, I think, the last issue, where from 2017, I think the issue was a little bit more than 50%. The probability of it happening, I think in 2017 they even went further to say, could a reasonable tribunal looking at this election say that it was conducted in according to the law?
Yes.
And that became the qualitative test, even before you get to the numbers, that you can simply strike an election based on the lack of following the constitutional principles and the legal requirements. But the standard is that it's not, I have found a mistake, therefore nullify. I have found an error, therefore nullify. The standard is above 50%. That if you look at this election, was it that bad? And to just put that standard in context, remember what was there in 2017. The server was not opened. There was no physical Form 34A. Chebukati declared the winner before he received all the Form 34A in original, using provisional results that was messages, actually, that were sent from the polling station. When they were asked to bring the original Form 34A, they brought duplicates and copies that did not have the security features. Remember the requirement to transmit results, both manually and digitally, failed to a greater extent. Remember the idea that the KIMS failed generally to transmit the digital result, and therefore the court looked at the whole thing and said this thing is not verifiable, it's not accountable, it's not accurate. We don't know for sure where you got your results from. Now, this time, of course, IBC will try to convince the court that last time you came and you said we did not meet the threshold. The election was conducted in disregarding general and important principle and law. This time, of course, you know, according to IBC, they're saying we had a portal, which is the server. This time, they are saying, you know, for the 4 days verification which was going on in Bomas was actually of the physical Form 34A. Remember, they already brought all of the original, or most of it, from the 44,000 polling stations that are there. At this point, they are also saying, you know, this is the technology, the KIMS kit did not fail to transmit the results.
Okay.
And so generally, you know, court must balance that election is done by infallible human beings. It must not be perfect, but it must, to a larger extent, be done according to the law. So the standard is a little bit above 50%. That when you look at this election, was it that bad?
Okay. Norman Magaya, in layman terms, there's 9 issues, there's a 7-judge bench. Will it be a consensus on issues, a majority of the issues by a majority of the bench, or could it be even on one issue by a majority of the bench that will carry the day in terms of the judgment?
You know, we have 9 issues, and those 9 issues are supposed to guide the parties participating in the case in the manner in which they align their evidence and presentation in court. But at the end of the day, the Supreme Court will have to determine 2 material questions. Whether the presidential elections conducted on the 9th of August was conducted in accordance with the Constitution and electoral laws, and 2, whether the 9th respondent was validly elected. Those are the 2 material questions that the court will settle and dispense with. And I think the threshold Dr. Yuang is trying to present is a threshold actually unknown in law. I've just heard from him of 50% and above. The material question, if you look at the way the court has framed issues, largely, 1, process. Okay? Did the process satisfy the criteria set out in law? The principles of our electoral system are set out in Article 81 of the Constitution. It says the Constitution, the election or technology deployed should be simple, should be accountable, should be verifiable. okay? And it should be transparent.
Yes.
Was the result transmission transparent? Was it verifiable? Okay? Chebukati has been touting, asking Kenyans, everything is on the portal, interact with it. When you interact with those forms on the portal, what story do they give you? They give a very, very interesting story. Just a cursory download and analysis of that form, even from a layman's perspective, will tell you a story. The forms are transmitted by Kim's kit, okay? They're supposed to show you this is a form coming from Senende Primary School in Kaimosi. Yeah, you will be able to know if you downloaded that form. If you go to the properties of those forms, I doubt you will get that information. So does it make it verifiable? Okay. The other thing is efficiency. Was the system efficient? Mm-hmm. Were the results displayed in time as contemplated in law? Remember that IBC had a dedicated VPN for transmission of results. Okay. Was this done? Okay. And that is why you can see court granting some of these scrutiny orders to try and verify this. The second issue that you've seen is in our electoral process, there is a protocol for every decision that IBC is supposed to be made, either set out in the Elections Act or the General Election Regulations, mm-hmm. and partly guided by jurisprudence coming from court, largely the Maina Kiai case, okay. and the Raila Odinga 2017 Supreme Court decision. Okay. Were these decisions made? It has framed an issue on the authenticity, alterations, and so forth of Form 34S. Yeah, we've seen situations from the pleadings without delving into the evidence, yeah. Allegations of deleting and uploading. Mm-hmm. The requirement is that Akim's kit takes the photo of Form 34A and transmits, and once it transmits, it cannot take another photo. So where is the protocol in law that allows another individual to download a form that has been uploaded by a presiding officer, yeah. and upload another one? Okay. Where is it provided for? So these are some of the questions that court will have to contend with. Right. And at the end of the day, then it will have to distill these 9 issues into the 2 overriding issues, whether the election was, yes, conducted in accordance with the Constitution, and whether the person pronounced as a winner was validly elected. All right. Yeah.
Okay, and I'll seek clarity on whether it will be majority of the 7-judge panel and just how people can expect this to play out. But in terms of playing out, there is the countdown now, and it should be 51 minutes to the hearing beginning at the Supreme Court. Duncan Hayemba, good morning, sir. You're joining us from the Supreme Court. The ground rules have been set as of yesterday. Where uko kwa ground? Does it look like we are starting on time? And what are the activities there from what you can see?
Yes, Mark, Nico ground, and a lot of activity, just security heightened. I can tell you all the way from I'm sure you know this part of the country, towards Uhuru Park. Security officers are dotting the way, the road as you make your way to the Supreme Court or the Milimani Court. Security has been beefed up. What you can say, it is up to the hilt. Everywhere it's dotted blue, blue, blue. But when you can, as you can be able to see behind me, there were sniffer dogs here. Anybody coming in with any equipment, it has to be subjected to serious security check here. And the sniffer dogs, or the officers on 4 legs, the ones that are doing this particular screening, sniffing. Of course, metal detectors are all over. As you can see, the officers, the 4-legged officers, are here making sure that anybody coming in with any equipment has to be sniffed. I can see there's a lady there. I can see them on the move. Of course, that is just to explain. That is a lady who is walking in, and now instructions are being offered, actually given to that particular officer who is with the other officer, just to scrutinize. rather to check the contents. That tells you how matters are being handled here, being not taken lightly, so to speak. But in terms of the ground rules, yesterday the bench gave a breakdown on the amount of time that parties will spend. Of course, the lion's share has been given to Raila Odinga, Martha Karua, who were termed as petitioners number 1. In terms of application, they were the 5th. But after the consolidation, they've been termed as petitioner number 1, who will have 3 hours. Other parties also that will have 3 hours is the first respondent, William Ruto and Rigathi Gachagua. The rest, whether you are part of the petitioners or the respondents, they will have to use 30 minutes each to make sure that they actually prosecute their cases in terms of trying to convince the bench. Remember that the burden of proof is, or rather they always say in this part of the country or this part of this career, that he who alleges must prove. And therefore the 7 petitioners who have been lined up to prosecute the 2022 presidential election number 1 will have a combined 6 hours to convince the judges on why this particular presidential election has to be nullified, if that will be what will be granted, because in some of the petitioners they are saying they want it being an election court to retally and to scrutinize and where possible levelize the ground. And if they'll find that there were some anomalies or figures that were wrongly given or denied, then they must pronounce who is the winner. Now there is that debate with regard to what Article 140 of the Constitution says with the mandate, but we also have other election laws which they will be asking the judges that despite this being the court of first and last instance, once they realize that there were anomalies, then the next step should be, if they will correct, and being an election court, they should automatically declare who is the winner in that context. That is something that we'll see how will it pan out. We didn't see it happen in 2013. We didn't see it happen in 2017. Now, just to take you through who will be appearing today, the first ones to take to take the mic or the stand will be Raila Odinga. 3 hours. We'll have 4 lawyers that have been, or advocates that have been allocated. Then we'll have Njoroge Kamau. We'll have the Youth Advocacy Africa, Halifa, David Kariuki Ngari, Okia Omtata, Julia Nchege. Those are the 7 consolidated petitions that will be heard today. And then tomorrow we'll have the respondents led by William Ruto and Rigathi Gachagua. And then on Friday, it will be the responses on what will have transpired. But tomorrow, something critical will be happening at 2 p.m. Of course, the lapse of the 48 hours that have been given to scrutinize ballot boxes, the election, the kits that were used to transmit the results. The 48-hour period will lapse. That is when the report will be handed to the judges. So that is something that will also be significant. That is what we'll have, or that is what we have in terms of the ground rules, Mark.
Submissions there, and the time allocation given in even the important 2 p.m. Slot in terms of the deadline for the scrutiny that was directed, and indeed the Githumu guys said that they have already started to comply with that, so it's in motion. What other issues stood out for you? There was the directive on server access, and I believe this time round people will not be asleep, those who are in charge of the server.
Yes, and that is what you would call the elephant in the room with regard to this particular petition. I don't remember seeing it in 2013 or 2017. 2017, as you've said, the server operators were said to be asleep in France, and when they were told to open the servers, it was said that they couldn't. There was that order that the servers be opened that never came into fruition, and then even the partial access, the read-only, there were issues in terms of accessing, but this particular one, this could be a game changer. Raila Odinga had demanded that a recount be conducted in at least six counties. That one wasn't granted. However, his prayer that at least 15 polling stations has been granted. That is the scrutiny that started yesterday at 2 p.m. What does this mean? If the petitioner will prove that at least from the 15, they were anomalies, and if the numbers will be significant. Remember, at the surface, at that surface level, the difference between Raila Odinga and William Ruto is about 233,000. Now, picture this. In the event the 15 polling stations, they retally, they open the ballot papers, then find that the numbers are maybe less than what was declared in favor of maybe the deputy president, or whatever was allocated to Raila Odinga is not what is reflected from the 15 polling stations. That is a sample. Then that could be a serious decision or a serious effect with regard to the direction this particular petition will do. Now, as I've said, Raila Odinga had wanted 6 counties. That is among them Nandi, Kericho, Bomet, Kirinyaga, Nyeri, and Nyandarua. However, the sample that has been given of the 15 polling stations still falls within those particular counties. Therefore, this could be the game changer insofar as this particular election petition is concerned. If maybe Raila Odinga was, maybe he has put a case that they were votes that were given, that were exaggerated, maybe in favor of his main competitor, or if the votes that were allocated to him on Form 34A and Form 34B and subsequently Form 34C is not what is reflected in those particular ballot papers. So it is a matter of wait and see, and as I've said, maybe that could be the game changer in this particular presidential petition, Mark.
But there's been quite some restrictions. You've mentioned it in terms of the legal team, the litigants who will be allowed, access to the Supreme Court, the main Supreme Court, where all the action will be going on. I believe you will be one of the journalists who will have access to that. This sticks out as maybe one of the main changes from the 2017 petition, as well of definitely the 2013 petitions. That was a packed room in 2017, but it's now quite well spaced.
Yes, as I indicated earlier, the social distancing is being practiced as per excellence in this particular scenario. Remember, in 2013 and 2017, we witnessed a jam-packed Supreme Court. In what you could say, it was a show of might. You could see then NASA, the legal watchers they had mounted, the who is who in the legal arena. You could see equally jubilant then. Then we had other interested parties. It was even a problem for the bench to access. Now this time, courtesy of the COVID-19 health protocols, they have spaced out. Even for journalists, we have a media tent that is outside the Milimani courts. Remember that all activities, all other courts have been told to continue transacting online. So this is a temporary seat of power for the Apex Court. They've moved from the CBD up to here. Inside the court, it is well spaced. There are very limited number. Therefore, it is a game changer for any advocate. This is a very big case that it gives you what you can call the bonga points or the mileage if you would participate in a presidential election petition. We saw a big number, a battery of advocates that were paraded in 2017. This time round, it has been significantly reduced. As I said, they've demolished that mountain of the learned friends that we expected to see. Many of them had prepared to participate in this third election of the Supreme Court, but that is not the case. Also, other changes that we are witnessing when you do a comparison, the 2013, 2017, 2022. Of course, this is a totally new bench. In 2013, we had 6 judges. Then we did not have the DCJ because Nancy Baraza had been removed from office. So 6 judges rendered that decision. That was said to be unanimous. 2017, we had also 6 judges because one of the judges was not able to sit through to the conclusion of the 2017 petition. Now, what happened, it was not a unanimous decision. It was a decision of the majority because 4 judges voted in favor of nullifying the election petition. I can see Professor Kithure Kindiki among the Deputy President William Ruto's legal team walking in, robed in I don't want to use the Zaki Zuasame's description of the hair because that is a robe, but I can see they're already walking in readiness of that. So I was saying in 2017, the bench did not deliver a unanimous decision. It was 4 against 3. When you look at that composition, it was totally new in terms of the top notch. We had a new Chief Justice, David Maraga, who had taken over from his predecessor, William Tunga. We had Philomena Mwilu, who had taken over from Kalpana Rawal, who had retired. And then we had, in terms of the depth, we had Professor J.B. Ojwang, who is very thorough in terms of giving his arguments and all that. He was among the 2 that dissented. So that is what we expected. What do we think of 2022? It is a matter of wait and see on Monday 5th on how the judges will render their decision. Will it be a split in terms of majority and minority? Will it be a unanimous decision? Those are some of the comparisons that we'll be able to see, but by and large, this is totally a new bench because it has the new Chief Justice, Martha Koome. It also has a new entrant who was the president of the Court of Appeal, Justice William Ouko, who is also very thorough, calm, and collected when it comes to dispensing or dealing with cases that we've seen previously. How will this one be, how will the cookie crumble in this particular scenario? Those are some of the comparisons we would want to see then when we'll do the comparison between the first election court of 2013, the second presidential election court of 2017, and now this third particular one that, as I've said, interestingly also has a new Chief Justice or the president of this court at the helm. Mark.
And a lot of eyes will be on the Supreme Court, the apex court, and the decision that they will arrive at by the deadline that is on Monday. It is 37 minutes to when we were expecting to have the Supreme Court hearing start. From what you see, Khaemba, just before I let you go, I've seen some people check in and, as you say, being scrutinized by the 4-legged officers. But have you seen any key petitioners, litigants who have arrived so far?
Not so sure, but we will try. I wanted us to try our luck and see if we can access the chambers, but I can see security is tight. But we just wanted to try our luck with the Basweti here, who is not so keen. But we don't want to rattle what you call we don't want to rattle the officers there, but we would have tried. But so far we've not seen the legal team for the petitioners. What we've seen is the legal team of the first respondent, Professor Kithure Kindiki, walking in swift. So we are not so sure, but there is another entrance in here that even the bench will use. So we are not so sure whether some of the legal minds will use, because some of them are very senior. They are the senior counsels, so we don't know whether they have the privilege to use other entrances. But since we started planning to go live here, we've not seen any from the respondents walking in Mark.
All right, you stay put there, Duncan Khaemba. I wouldn't want you to get into trouble, you and Basweti, so don't go beyond your bounds in terms of the restricted areas, but you have confirmed that there are some key litigants and representatives who have arrived, and as soon as the hearing is set to begin, we'll be crossing over live. But in the meantime, I will still be kept company by advocates Norman Magaya and Dr. Duncan Ojwang in studio to break down the 9 issues and areas of determination. And if you have any questions, you can call in just to put it to them. But we'll take a quick break at the moment. Be back in a bit. Stay with AM Live.
Mivida Garden City, a residential development within Garden City offering stunning 1, 2 and 3 bedroom apartments, unique amenities and an urban green convenient living. Call us today on 0722 123 000. Mivida, my home, my life.
Difficult times ahead for the business. But with all that being said, I really need to finish this meal. Okay, I'll have one.
Ha! First you twist it, and then you lick it, and then you dunk it, and then you eat it.
Did you know that the hospitality industry is one of the world's leading employer?
We offer internationally recognized certificate and diploma courses in culinary arts, pastry and baking, hospitality management, tourism. Join us today and let us make you a professional. Cascade Institute of Hospitality, an oasis of excellence.
Chief Principal, Eldoret National Polytechnic, Mr. Charles Kowech, wishes to inform prospective students that admission for the September 2022 intakes is ongoing. Apply now for a course of your choice. Visit www.tenp.ac.ke.
Now this is a celebration. The finals, when 60-foot prayer can get answered at the buzzer.
It's more like 61 feet.
I mean, you gotta be great from game 1 and game 7. Because when the champagne stops popping, does anybody know what's left?
Legendary status, my man.
Yes, Dirk. Exactly. Oh my greatness.
Dave, this line is not going down, and you're burning up. But I'll sort you out, my friend. See that barrier? Go for it. Yeah.
Bing bang bing. Bum, bum.
Who is that, Mother?
Oh, it's Dr. Sarmiento, dear.
What did he say?
He's insisting that he doesn't believe that I have a gambling addiction. And he said that we should cancel the appointments we made.
That's what he told you?
Yes. I told him that. I won't. Because I'm going to do this for my family.
Okay, what are those?
Don't you see the rings?
I see that, but...
Look. Both our names are engraved on them, you see?
Yeah, I see it, but aren't we a little too old now to be doing these things?
It had to be you.
Get peace of mind and protect the ones you love with the power of Dettol Bar Soap. It
cleans and protects from up to 100 illness-causing germs. So no matter what type of mum you are, trust Dettol.
The Nairobi well-trained doctors and emergency nurses who are focused at saving lives. With a network of labs, you're guaranteed of accurate medical test results. The Nairobi Hospital is a center of renal excellence, providing cutting-edge technology with over 10 dialysis machines.
Welcome back to AM Live, continued coverage in Decision 2022. And quite important at this point with the Supreme Court petition hearings beginning today and for the next 2 days. And then they would retreat for a decision on this matter and would decide the direction of the Supreme Court judgment and the verdict by Monday. So as everyone awaits this, we at least have 9 areas that the Supreme Court has drawn out that will be of focus. And I want us to get into that with Norman Magaya, an advocate, as well as Dr. Duncan Ojwang, an advocate as well. And as we refer to this and we break it down, first of all, there was the issue before we crossed over to Duncan Haemba, and he did mention in covering the 2017 petition, and, you know, it wasn't a unanimous decision. And to Norman Magaya, you did mention that it's going to be on 2 main themes, how the constitutionalism or how constitutional the decision was in terms of going through all the areas of concern and the process, and whether the declaration of the president-elect was done legally and procedurally. But to that question of whether there will be a breakdown of each of the 9 issues and whether it will be necessarily laying on the majority of the issues or even on one by the 7-judge bench. And then would it be that it is a majority of the 7-judge bench, 4 out of 3, arriving on a particular issue decisively? What is the expectation for decisive judgment and verdict?
Yeah, so, you know, the court has distilled the 9 issues.
Yes.
But at the end, it has also said what consequential orders and reliefs court can give. And if you look at all the petitions, there is a cocktail of prayers and reliefs that the petitioners are seeking. The guide for the Supreme Court is Article 140 of the Constitution that gives it original jurisdiction to inquire into the conduct of a presidential election. And so court will be guided largely. The 9 issues, when court eventually hands down its detailed judgment, the 9 issues will be clear on how it resolved each and every issue based on the evidence that was availed. It may decide that most of the issues were proved, or that some of them were proved and some were not proved. A split decision of the Supreme Court, I think, serves our nascent democracy well. It gives a fair chance that those who have nullified or upheld the election are able to give the rationale for so deciding, and those who have dissented to either uphold or nullify also advance their rationale for so doing. It's good because it provides the basis for future development and fixing of our electoral system.
Okay.
Given the 2017, we had a split decision. You look at the composition of the Supreme Court now, I will go 0 out of on a range of 0 to 10. Unanimous, I will put it at 7.
Okay.
Split, I will put it at 5.
At 5.
Yes.
Dr. Ojwang, and just to explain this to the layman, the makeup and the constitution of the Supreme Court being a 7-judge bench is ideally to, do away with a scenario where there would be, in the strict sense of the word, a split decision of 4 against 4, for instance, if it was an 8-judge bench, just to explain that for the layman in terms of the constitution of the Supreme Court. And in your view, doesn't necessarily have to be a unanimous decision, or at least a majority of the 7-judge bench having arrived at a particular judgment or verdict decisively.
Yeah, you realize that this time all of them are seated. In my view, for any application to succeed, you'll have to have the majority. Of course, as you presented, there is no scenario of having equal number out of 7. But if in any case you don't have 4 out of 3, then whatever the application is not supported. Even if assuming there were 6 and there is 3 on each side, then it means there is no majority on that, and that application then is not the majority, and therefore it fails. So there is need for those who approach court to have majority on their side in every issue.
Okay.
But I think the issue that probably Magai was reacting to, in 2017, there was the issue of threshold.
Yes.
The issue of threshold, and the court said, you know, balance of probability, the issue of could those mistake, one, the mistake affect the results. That is direct, that is quantitative. Did maybe Ruto make 50 plus 1 or not? Did he win? That is a matter of number.
Yes.
But then there is the matter of the process also, where questions like, was this election conducted by law, that he was explaining very well. That also, for the Supreme Court, the standard or the threshold to be met in 2017 was above probability, that not every mistake avoids an election. It must reach a certain threshold. And unless they come with a different standard in 2017, then that is what they applied in 2017. In 2022, that's what they applied in 2017, because they were saying overall this election in the balance of probability was not conducted according to the law.
Okay.
Of course, the Constitution gives those principles that election must be fair, verifiable, simple, accurate, accountable, and that must be proved. But at what threshold do you say, must it be 100%, maybe 90%? And that is where there is a little bit of conversation of what is the overall threshold to be proved.
All right. And so just to close that question, a majority can decide on one issue, and if it's seen as substantial to the overall result, whether or not they all agree on the 9 determining factors, this could carry the day in terms of the judgment on Monday.
Yeah, because, for example, on the first issue on technology, it's a legal requirement. It's not just there for aesthetic purpose.
Yes.
That there must be, by law, transmission that is verifiable through technology as much as the manual. And so on that issue again, I think if they vote issue by issue, but overall, the effect is that if you look at this election, was it conducted according to the law? Did whoever was declared the winner win? So that is the ultimate question that they are trying to answer.
All right, looking at these issues, number 1 and number 2, quite related here. Did technology, number 1, deployed by IEBC meet standards of integrity, verifiability, security, and transparency to guarantee accurate and verifiable results? And number 2, was there interference with uploading and transmission of Forms 34A from the polling stations to the IEBC public portal? How it will play out in court, Norman Magaya, and this is related to the scrutiny that has been granted first to the polling stations, the 15 polling stations or polling centers, as well as the servers. Is that correct? Is that how they will be able to arrive at a decision on these first 2 determining factors?
Partly, yes. The scrutiny will be able to speak onto issue number 1 and issue number 2. But largely, also, if you look at the evidence on record through the affidavits, speaks to the question of whether the technology deployed by IEBC met the standards of integrity, verifiability, security, and transparency. If you've seen already substantial material on court record on interference, access to the technology by parties not authorized to access the system. You've seen this being raised both by the petitioners and some of the commissioners. And they are actually on the record affidavits by employees of IEBC, not just the commissioners. It will tell you that actually the contest is not just between the commissioners. There are actually affidavits sworn in support of the petition by IEBC employees and affidavits sworn in opposition to the petitions by employees of IEBC, speaking to the issue of verifiability, the issue of security of the system. And unlike 2017, what we have now is a bizarre situation. It's not actually a hacking trait. This was authorized access granted. And I think eventually when the Supreme Court retires to hand down the final judgment, this election, as I said, is the process through which we choose our commander-in-chief, that we've reached a level where we have foreigners gaining access to the technology that we use to choose our commander-in-chief.
So it
should be really troubling,
right?
And I think there must be consequences.
Okay.
Other than nullifying or upholding election, I think one of the things that the Supreme Court must stamp out is that those involved in manipulation of the electoral system, there must be pain that they must bear. I had already spoken to the issue of the question of Form 34A.
Yes.
That we have glaring evidence of forms being uploaded and deleted long after the results have been transmitted. No protocol exists, not in the general election regulations, not in any jurisprudence on our election laws, gives that power. Above all, on this question of 34As, I've seen, without delving into the depth of the evidence, communication by regional IBC, ICT managers, raising concerns. Elections have closed, you have 7,500 KIMS kits still active and transmitting, yet once it transmits, it's supposed to shut down. So it raises the questions of integrity and security of the electoral system that was deployed. So these issues will play out,
yes,
depending on the evidence that is adduced. And just to clarify with the question of threshold, I think one of the things that we did successfully in 2017, because I was involved in that petition, was to persuade the judges and move them from the jurisprudence that the Mutunga Court had set in 2013. In 2013, the Mutunga Court had said that the burden of proof is such that it is not beyond reasonable doubt,
right, and
not on a balance of probability, but somewhere in between. So that was an unattainable balance because you don't know where it falls. And we were able to persuade the court that we need to address this question disconjunctively, that if the irregularities have been substantial, you don't need to demonstrate that they affected the result. And that is how the Supreme Court departed from the question of numbers and says it is the process.
Okay. Yeah. Dr. Ojwang, we spoke about this a bit earlier, but there's something as well in terms of how these issues will be approached by either side of the litigants. Number 2 here, and I'd want us to speak to it in light of the Maina Kiai case and results being final at the polling station, how that will weigh into determining was there interference with uploading and transmission of Forms 34A from the polling stations to the IEBC public portal? How will this weigh in terms of precedent?
There is the order to scrutinize the system.
Yes.
And see that there was no interference. Of course, I've seen the affidavit of the person in charge of ICT dismissing a lot of claims, which, you know, moved from there was attempt to hack.
Yes.
To that attempt to hack has interfered with the results.
Yes.
And the attempt to hack probably must then be proved. Did it bear? Did somebody succeed in hacking? And it's the IBC by itself that came and said, we have seen people trying to hack. Of course, you cannot attribute it to whichever side. You don't know the hackers' affiliations, whether they were hacking for who, but that they tried and they failed. And but I think it is there that the so-called the ghost of Venezuela comes in with the report that they had some sensitive items.
Yeah.
But the issue is, were they unauthorized to have them, knowing that part of the technology was being supported by a foreign company? And so, to what extent is the sensationalization of issue of foreigners with sensitive material practical, knowing that the foreign company was actually the one doing this? The idea that at some point, did they actually interfere with the results? And ultimately, I remember the reason for the dual mechanism of both digital and manual is verifiability.
Okay.
That you can use one to verify the other. That you can have the manual and say what is in the portal is different from what I have, because it is the same polling stations. And so it should be very easy to catch when there is a switching of the results.
Okay.
And remember, both parties, ideally, were encouraged to have agents, and it will be indolent of any party not to have their agent. Remember, the duplicates from 34A original was to be given to each party agent.
Yes.
So you already have your evidence. You are not going to Bomas to look for the evidence. You have your evidence from the polling station. Then you go to the portal with that evidence, and if you find something that does not add up, you wait for that original from 34A, which were verified for 4 days, to check the original and the security features.
Yes.
For 4 days. That happened in Bomas, so that you can find that here is the form that we came with from our polling station. This is what is in your portal. As an agent or as from original, it has been changed. And so ICT people, in fact, Kanjama's team also with ICT experts were admitted as amicus. The allegation of hacking or lack of it, and to what extent did that hacking switch the result? Remember, according to Chebukati, the results in portal were provisional. That the result declared were based on Form 34A original.
Okay.
That were tallied, verified for 4 days or 5 in Bomas.
And that's what I was just bringing up, and
Mark,
also
Mark,
in the third issue. Yes, Norman.
Just before that goes.
Yes, Norman.
Dr. Juang is talking about verification and all that before announcement at Bomas. Show me a single minute of the commission. In 2013, 2017, IBC filed its response accompanied by minutes of the commission detailing the verification process and announcements of results. Show me one for 2022. It's not there. Okay. The issue of interference in the election technology by foreigners, it's not a street talk. It's an actual thing that is demonstrated by evidence on record. It's something that we cannot sweep under the carpet and say these guys participated in the process. The law required. And that's why I said that this manipulation was actually a project conceived many months before the election to procure a company that on its own admission, in its own admission, conceded and confessed to have manipulated the electoral process.
If it was known, as you say, if it was known as it says, let me just put this to you. If it was known, then why would the participants go into the election knowing this?
I'm just walking through the procurement gaps and what was required. Okay, they take mathematics. The CEO and the chairman say, we never found out about these issues. We relied on the report of the due diligence committee. I mean, damn it, they chose it knowing that it was user-friendly. It was meant to achieve an end objective that they had conceived to implement.
Someone watching this would then ask, would the main participants in this election raise this issue and not want to participate in something they feel would have already been tilted to someone else's favor?
Thirdly, the tallying of votes from Form 34B to 34C by law is a manual process. What we have was not a manual process. It's mathematics on account of evidence filed by IBC itself.
All right.
Did electronic tallying of the votes contrary to the law.
Okay.
Yeah? So we have flagrant violations that you do not need evidence from elsewhere to prove, but from the findings.
But we'll see and how they determine on this. And as Dr. responds, we can see the Apex Court filling up as we are looking forward to the hearings beginning.
Of course, the audit will show whether alien came and hacked. We don't know.
It's not hacking. It's authorized access.
Aliens exist. They might have come and interfered as aliens.
Yes.
But at the end of the day, remember the process of counting and tallying started at the polling station. That the votes were counted. I was in a local polling station where we counted those things in our vernacular because we were all of the same language. So the counting did not start in Bomas. It was done in 44,600 polling stations. And with that, Maina Kiai, which said that the results at the polling stations are final. So if the polling station and parties are supposed to have their agents, so whatever happened in the Bomas is actually the fourth, third bite at the cherry. There was the constituency, the same thing happened, another tallying opportunity. At the polling station, a party had even a chance to say, I don't agree, let us recount.
Right.
Nothing happened. If you look at the IBC diary, there was no issue. And that is why, then for the other people, they are saying, would you have thought of this if you were the winner? Or this is an afterthought?
Okay.
You know, he's trying to argue an issue that is settled jurisprudence. This issue of having agents was raised in 2017, and the Supreme Court dispensed with it. It is the duty of IBC to secure the vote and accurately ensure the vote is protected and an accurate result announced. The question of parties having agents is neither here nor there. But it is like somebody telling you. It is like somebody telling you. It is like somebody telling you it's okay. Your shop was robbed because you have not hired a chairman. To hell with you! It's the government's duty to protect security. It cannot depart from that duty. It is settled jurisprudence. You cannot argue otherwise. It doesn't fly.
Secondly, what about the finality of the results?
I have spoken about this being a vote manipulation project. Part of this were the returning officers. Unilateral appointment of returning officers by Chebukati and the transfers undertaken in March. The presiding officers handed over all the Form 34As to returning officers. It will interest you to know that 34 returning officers did not post their results. If you analyze what Chebukati has been touting on the portal, those Form 34Bs are generated by the same machine, uploaded from the same machine from a central location. What does the law contemplate? They are being uploaded separately from different constituencies. How do they end up on one computer being uploaded? I mean, you have glaring questions that speak of criminality, and somebody must be charged for for treason for trying to establish a government in a manner contrary to the law.
Okay, and Dr. John, I don't know if you wanted to give a final comment here.
I think we are the real drama is now going to court, but I think you know, court is guided by evidence, and the idea that the counting was not happening in Bomas for the first time. Okay. That the 44,000 polling station, and if you look at the diary of each polling station, and even the agent signing, there is one affidavit by ODM agent who is saying that form that you are bringing that was altered is fake.
Okay.
And so let us just wait for the court. But I apologize if aliens hacked.
You are speaking, we are not talking about hacking. We are talking about authorized access by Chebukati.
All right, let me hack this conversation and then or interfere with it, Norman Magaya and Dr. Juang. As we see it's about to start, as we see it's about to start, let's just take a quick break, Bwana Norman Magaya, because it's just about to start and it'll be ongoing coverage as the hearing begins. So just a quick breather before we get back to this as it's filling up.